What's up, everybody? We are back at it today, hump day. It's Wednesday, a lot's going on. And what are we talking about? But Amber Heard and Johnny Depp. Because, as we've said before, it's the case that keeps on giving and just won't go away. And there has been a response filed to Johnny Depp's brief on one of the more interesting issues in the case. It's got crossover with the Gabby Petito case. It's what we said during trial was one of the more interesting things that the judge was going to allow to go forward and could be setting some dangerous precedent, and that is whether or not Adam Waldman speaks for Johnny to the level that there could be defamation. And it seems like if we're listening to Gabby Petito's situation, maybe Amber could even have a claim for defamation against Adam Waldman. But thanks for joining us. And we're going to continue to hit this case as long as you guys are requesting it. And a bunch of you sent me this response brief, asked what I thought about it. You know, it's kind of a topic we've been heavy-handed on in other videos here and something that we are interested in. So we are going to read through it today. We're going to read a lot of pages. We're going to skip the beginning where it talks about the statement of the case. If you don't know what's going on in the Johnny Depp and Amber Heard case, I can't help you. Actually, I can, because I just saw this comment come through from Ritz. I subscribed recently and have been binge watching all of the Tragos team videos. Awesome. Thank you, Ritz. And that's the best way to catch up on what is going on with Johnny Depp and Amber Heard. And that is what we're going to be discussing today. So I appreciate everybody joining me. If you would hit the like button before we start, we can get that out of the way. And we will, oh, I see somebody got COVID for the first time today. That sucks. I'm sorry to hear that. Hopefully you're just tucked in watching YouTube videos now, right? It could be a worse way. And Ellen, not Sarah Lee, is a new member. And I'm really excited about the members video that we're going to do this week or this month, which is the my top 10 favorite Christmas movies. So we're going to talk all things Christmas movies. We'll probably do some Christmas movie trivia because that's like my favorite thing. And we've already hosted, I think, 3 Christmas parties at our house, and we still have 2 more left. And at a couple of them, I do this fun Christmas trivia, Christmas movie trivia game, movie and Christmas song. So make sure you guys check that out if you want to join the membership crew here. Jilly Bear loves the law firm Shorts. If you hear things going on in the background that sounds like construction, that's John, who's here in person in my office and setting up some stuff for the future. That's going to be fun. So keep a lookout for that. But without further ado, let's jump in to Amber's response. Let's see what she has to say. All right. The only thing notable on the first page is that Ben Rottenborn seems to be the only lawyer, counsel for the appellee or appellee. And we're going to skip through all the citations. This is the quickest we're going to go through any pages in this brief. And then the statement of the case. Like I said, we've been over this so many times. We know the statement of the case. We know the statement of the facts. But let's get to the argument. Okay? And we'll start with them talking about Johnny's intent to retaliate. Oh, no, actually, we've heard all this before, right? We've heard what Waldman said. Let's get to, we heard what they refused, the argument. Here we go. What lawyers do best, right? Argue. So here we go. Mr. Depp's independent contractor theory. Oh, that's too much. Mr. Depp's independent contractor theory is an opposite, and whether Mr. Waldman is his agent was a question of fact. And here's something that I want you to keep in mind as we go through this appellate brief, okay? Everything Amber Heard's lawyers are going to argue, everything that they say is a question of fact. The reason they say that is that means the jury should decide. And every time they say this is already settled, this was a question for the jury made their decision, Johnny's stuck with the jury decision. I don't necessarily disagree with them. And although I disagree with how the jury came to its conclusion in this case and how I'm not thrilled with a lawyer's public statement being held against his client for defamation, usually it's settled once a jury makes a decision like this. And usually that is the strongest argument to lean into in an appellate brief. And that's exactly what Amber's lawyers do here. However, that same argument can be used in the opposite argument responding to Amber Heard's appellate brief. That all of that was a jury question. The jury made their decision, and now you have to live with their decision. But let's see what Mr. Rottenborn says. And I have not read this, so this will be the first time we're reading it together here. And of course, I'll answer your questions throughout. All right, what's the standard of review? A plaintiff who is armed with a jury verdict approved by the trial court stands in the most favored position known to law. Ain't that the truth, Ben Rottenborn? Not just when you like the jury's decision either. When the trial court has refused to strike plaintiff's evidence, the well-established standard of appellate review requires this court to determine whether the evidence presented at trial, taken in the light most favorable to the plaintiff, was sufficient to support the jury verdict in favor of the plaintiff. Whether the concept of an independent contractor applies to this case is a question of law that is reviewed de novo. And whether Mr. Waldman was acting as Mr. Depp's agent when he made the statement was a question to be resolved by the jury. So the concept of independent contractors applying to the case is a question of law, but whether or not he was acting as Johnny Depp's agent is a question to be decided by the jury, and the jury's finding should not be disturbed on appeal unless it is plainly wrong. Mr. Waldman can be both an independent contractor and an agent. This is an interesting argument here. And Catherine Joy with a big super sticker. Thank you, Catherine. Appreciate that. It'll add a highlight to our screen as we read through some black and white words on the screen here. So Mr. Depp claims that Mr. Waldman is, as a matter of law, an independent contractor rather than an employee agent, and is thus not liable for his statements to the press. Agency is defined as a fiduciary relationship arising from the manifestation of consent by one person to another that the other shall act on his behalf and subject to his control, and the agreement by the other so to act. When an agent commits a tort while acting within the scope of his authority, the principal is liable. So that is true, right? So like a FedEx driver driving a FedEx truck, FedEx is liable. It's not just the driver that somebody can sue. So this agency relationship is important, that if this was in fact the relationship here, that the principal would be liable for the agent's actions. Even if the principal does not authorize, justify, or participate, or indeed know of such misconduct, or even if he forbade the acts. Another case recognizes that defamation may be based on statements made by an agent. An agency relationship can arise in any circumstances and is not limited to the employment context. Affirming the jury verdict against a mother arising from a motor vehicle accident caused by her son who was acting as an agent when the accident occurred. That's the situation I just explained. I agree with all this. This is well settled law in most places that the principal is vicariously liable for the actions of the agent. In the employment context, a person's status as an independent contractor precludes the existence of an agency relationship. The doctrine of respondeat superior imposes liability on an employer for the negligent acts of its employees. If, however, the negligent acts were performed by an independent contractor rather than an employee, no master-servant relationship exists between the contractor and the employer, and the employer is not liable for the negligent acts. The concept of an independent contractor, however, does not apply in all agency contexts, nor does establishing an individual is an independent contractor defeat the possibility of an agency relationship. And then we're going to see some case sites. Vicarious liability may nevertheless be imposed for the actions of independent contractors where an agency relationship is established. Agency and independent contractor status are not mutually exclusive. I'd like to see more of that case because just pulling one line out of it usually is a bit out of context. Mr. Depp is incorrectly importing the concept of an independent contractor, which negates an employer-employee relationship, a specific kind of agency relationship, to all agency contexts. In doing so, he has presented a false dichotomy by arguing Mr. Waldman is either an independent contractor or an agent, but the two are not mutually exclusive. He can be both an independent contractor and an agent. he is an independent contractor. Even if he is, it does not preclude him from being an agent and therefore having liability on Johnny Depp. So as a result, that first argument is wrong. I don't think they've proven that with this case law personally, that just because you're an independent contractor doesn't mean you also couldn't be an agent. I'm sure that is possible. But if you prove that somebody is an independent contractor in a certain instance and in a specific situation, they're usually not also an agent. There would have to be additional facts that make them an agent in addition to them being an independent contractor. All right. I need some of those like blue light glasses when I stare at the screen like this for an hour reading this document to people. The circuit court properly denied the motions to strike because whether Mr. Waldman made the statement while acting as Mr. Depp's agent was a question of fact, again, meaning a jury question. And if it's a question for the jury, then the appellate court should not overturn it. In his opening brief, he relied exclusively on the independent contractor theory to challenge whether Mr. Waldman was acting as an agent. He has not asserted Ms. Heard presented insufficient evidence that Mr. Waldman was his agent or that he was acting within the scope of his authority. And those arguments are therefore waived. I disagree. Not that I disagree that they're waived. I disagree that he did not make those arguments. Ms. Heard presented, to the extent the court interprets Johnny Depp's contention that Mr. Waldman is an independent contractor as a matter of law, as challenging the sufficiency of the evidence on agency, the circuit court correctly denied the motion to strike. Whether an agency relationship exists is a question to be resolved by the fact finder unless the existence of the relationship is shown by undisputed facts or by unambiguous written documents. Whether a person is an employee or an independent contractor is generally a question of fact for the jury. Agency may be inferred from the conduct of the parties and from the surrounding facts and circumstances. A principal's liability does not turn on whether it directed the agents to take a certain action. We know this. We've been through this. This is something we've already read before. However, did Amber Heard actually present any evidence of this relationship? And I think Johnny Depp and his team multiple times argued that there was not sufficient evidence presented to actually prove that this agency relationship existed based on Adam Waldman answering that a lot of these questions, the answers were client confidential communications. Applying the test outside the employment context and concluding a mother was liable for damages arising out of her motor vehicle. It's literally the same case law here. We don't need to read it again. Accordingly, Mr. Depp's assertion that he is not liable because he was not personally involved in directing or making the statement is incorrect. So I think that the way I took Johnny Depp's argument that he did not direct or tell Adam Waldman what to say, when to say it, how to say it, was more of Johnny Depp arguing he's an independent contractor doing what he wants to do as a lawyer, not an agent. I don't think Johnny Depp was saying that I can't be held liable because I didn't tell him to say that. You get where I'm going with this? So it's a little bit of a different argument. If you admit that there's agency and then you say, but I didn't tell him to do that, well, you can still be held liable because FedEx drivers don't tell their drivers to get into an accident, right? But they can still be held liable for that. But if he's saying, I don't have control over what he does, I didn't tell him what to do, I don't control what he does, I don't control how he does it. And by doing that, it's showing that he's not an agent, not necessarily making the argument that I think Ben Rottenborn is appropriately explaining as not necessarily true. However, he's going to throw some facts at us that may show that he did want Adam Waldman to do this. Mr. Waldman was acting as an agent when he made the statement, was an issue of fact that the jury found ample evidence for. The evidence established that Mr. Depp seeks to retaliate against Ms. Heard for obtaining a protective order against him and filing for divorce. Shortly after announcing that he will stop at nothing to globally humiliate her, Mr. Depp retained Mr. Waldman, who serves as his primary counsel for all of his affairs and assists him with publicity. I think that this proves nothing. I think that this is Ben Rottenborn trying to throw some facts out there that make Johnny Depp look bad, that hope the appellate court looks at this and says, oh yeah, it's obvious he wanted to get Amber back, because I don't think this actually proves agency relationship or independent contractor relationship, which is the main point that we're supposed to be arguing in this appellate brief. And again, whether or not he directed him to do this, I think goes to show that this was not agency rather than he can't be held liable if Adam Waldman is his agent, if you pick up what I'm putting down. Mr. Waldman has spoken to the press on Mr. Depp's behalf on several occasions. For example, Mr. Waldman confirmed that he was accurately quoted in the Daily Mail article. Mr. Waldman identified as Depp's lawyer and attorney in each of these articles. Waldman also provided information about the case to several social media personalities and was present when a journalist for the Rolling Stones interviewed Mr. Depp. So what? Just because he's there for those things, just because he's his lawyer, does not mean he's his agent. For agency relationship purposes, I should say. Before the articles in the Daily Mail were published, Mr. Depp and Mr. Waldman met with the publicist for the Daily Mail. Mr. Waldman gave him 2 audio recordings, but could not recall if he did so at the meeting or another occasion. Waldman also generated negative press about Ms. Heard by filing a report with the LAPD. See, that is an argument, right? This is not something a jury determined. That Waldman generated negative press about Ms. Heard by filing that police report. You can also say that as somebody was the victim and his lawyer filed a police report against the abuser. Or somebody was the victim of somebody filing a false police report and you're protecting that victim and trying to get them justice by the person making that inappropriate filing. After filing this report, Mr. Waldman generated press about his own accusation by telling media outlets that LAPD have now opened up a criminal investigation into perjury of Ms. Heard, even though that had happened. All that had happened was Waldman made a police report. Technically, it still could be true. In summary, during the course of Mr. Waldman's representation, he and Depp met with Daily Mail, published a series of negative statements, confirmed they accurately quoted him, gave them audio recordings, communicated with other media outlets, and just generally was trying to produce negative content for Ms. Heard. Which again, I don't really think this entire 2 pages of negative things that they did has anything to do with what we're arguing about in this brief. Based on the evidence, a trier of fact could conclude the scope of his representation involved generating negative publicity about Heard or speaking to the press. All right. D, the court need not adopt any rule regarding whether attorneys are independent contractors as a matter of law. This will be interesting, but let's hit a couple questions here. John, couldn't the agent's principal be the law firm since the client hires the entire firm? It could, but it's really unusual for that to happen. I am nobody's employee, right? We talk about that. I do things the way I think they are best, which is always what's interesting about how you're going to hold people accountable for what an independent contractor does, right? If an independent contractor comes to your house to fix the plumbing while you're also doing construction and you got that independent contractor's name from the general contractor, you can't sue the general contractor for that independent contractor unless they have some contractual relationship. You can only go after the independent contractor if you want to. It's an interesting area of law. Azam, hi, Peter. I'm confused with her appeals filing now. There are too many at this point. How many appeals can a certain party file for a case and how many types are there? This is a response brief responding to Johnny Depp's appeal, talking about these Waldman statements. We talked about the amicus briefs, how they're just kind of people trying to help her out. And then she filed her own appellate brief. Creed, question. So in their logic, to establish Waldman as an agent, he has to be acting outside of his capacity as a lawyer, independent contractor to JD, and that he did that as an agent because he was doing his role as a lawyer. It's basically like he does whatever Johnny Depp says. Johnny Depp controls what he does, and he works exclusively for Johnny Depp is what I would think it sounds like. And that's why I would be apprehensive to adopt any ruling like this. And we're about to get to whether or not the court needs to adopt any rule about it is a correct point. Sarah Beth, hey, Peter, my team is playing your team in the Cheez-It Bowl, Boomer Sooner. Yeah, it's fun. So we did that home and home a few years ago against Oklahoma and lost both times, but they were really good games. So hopefully it's time for revenge. It's always scary taking on, a blue blood, as they say in basketball, a big time football school, even on a down season like Oklahoma's having. So it should be fun in Orlando. I don't think I'm going to be able to go because I'm supposed to be in North Carolina, but if I am home, I'm definitely getting to the game. JD opposition briefs. Oh my gosh. Can't wait. Yes, Barbara, I'm sure we will see that as well. And thank you, Andrea, for the super sticker. Let's get back to it. The court should reject his request to adopt a rule that clients cannot be held liable for their attorney's misconduct because they're independent contractors. What do you guys think? I think they should adopt that rule. I think if attorneys are going to do stuff because we have autonomy to a certain point on strategy and way we carry out cases, that our clients should not necessarily be held liable is our client's case. So if we say something on behalf of our client within that case, it can be used, but not in other cases. And then there's litigation privilege where what's put in these court documents and asked in court, it's privilege, and you can't then be sued. You can't. I have clients all the time ask me, can I sue this person for suing me? And the answer is no, or else there'd be even more lawsuits. First, several courts have held that attorneys are not independent contractors and have imposed liability on defendants for their attorneys, holding that a defendant can be liable for its agent/attorney's actions taken within the scope of representation, including possible torts committed by him, and that the trial court did not err by instructing the jury only on agency principles and not independent contractor law. That is a 2005 case. In 98, a case said that a client can be held vicariously liable for the actions of his attorney so long as the attorney is acting within the scope of employment and in accordance with what is believed to be the client's interest. So this is the point of the two previous pages talking about generating negative press for Amber Heard. Another case found that the client is vicariously liable for his attorney's intentional tort because the actions arose directly out of the business that the attorneys were hired to do and were committed for the purpose of accomplishing the mission entrusted to the attorneys. Again, I have an issue with this because if you tell your attorney you want to win the case, then the attorney goes and does something illegal. Did you direct your attorney to do something illegal because you told him you wanted to win the case? Because I think this same argument could be applied. And I don't think you should be held liable if your attorney does something illegal and he tries to say, well, he told me to win the case, so the only way I could win the case is do something illegal. So now let's, make sure we hold my client accountable for that too. No, the attorney should be held liable for that. All right. Arose out of an agency relationship. You can hold attorney accountable, accepting as true allegations that an attorney made defamatory statements to the press on behalf of the defendant and noting that it would be ultimately a question for the jury. Let's see here. Most of his cases are distinguishable. Recognizing that an attorney can act as an employee for his employer in carrying out non-legal functions or business transactions. Attorneys were retained for the sole purpose of collecting money upon a judgment when reaching its holding that the attorney was an independent contractor, unlike Mr. Waldman, who was retained for several purposes that include litigation or publicity. These are responding to the cases that Johnny Depp's team cited. Another case said someone is an independent contractor does not bar the attachment of vicarious liability for their actions if they're also an agent. Holding an insurance company was not liable for the acts of its attorneys, wherein imposing liability would make the company liable for actions it could not legally control due to specific New York law. I don't think Johnny Depp could specifically control what Adam Waldman's going to say about people, maybe even people he doesn't like, and the press. Noting a party to a civil suit cannot be liable for the intentional wrongful conduct of his attorney unless the client is implicated in some way other than merely having entrusted legal representation to the attorney, which is unlike the facts of this case. Mr. Waldman assists Mr. Depp with publicity as well as legal representation. I agree with the first part of this rule, right? A potential civil suit cannot be liable, the party cannot be liable for intentional wrongful acts done by an attorney. That should be true in every case, in my opinion. Even if a client tells me to do something, if I'm stupid enough to do it, I'm the one that should be liable for it. The attorneys should be liable for their own actions. People have to take responsibility for their own actions. If Johnny Depp would have said this specifically about Amber Heard, fine. Hold Johnny Depp liable. Hold him accountable for it. But as a lawyer who's a professional who's supposed to help him with these things, I just think it's a bad precedent to set. Third, several of the cases cited by Mr. Depp emphasize that imposing vicarious liability on a client for actions taken during the course of legal representation would lead to negative consequences for the legal system, including making parties reluctant to file suit or giving ill-equipped parties the ultimate responsibility over their legal representation and encouraging clients to micromanage their attorneys. Not just that, but you're also potentially allowing clients on the other side to just sue a bunch of attorneys, even if they don't have claims against the opposing party is the person they really want to sue. These concerns are minimal here, where Mr. Waldman spoke as Mr. Depp's agent to the press outside the bounds of a traditional legal relationship. So are you saying under a traditional legal relationship, they're only independent contractors that can't be agents? Because it sounds like you're arguing it the other way, even in traditional legal representation. Lastly, clients generally rely on their attorneys' professional skill and judgment with respect to the intricacies of the legal field. In such cases, clients have little ability to monitor whether an attorney's conduct is tortious because they lack legal knowledge. When an attorney speaks on his client's behalf to the press, no legal skill or judgments are involved. I totally disagree with that. Amber Heard sought legal counsel before filing or before sending in her op-ed. Statements made to the press, oftentimes people ask for legal representation or help with that, or legal judgment and professional skill. So I disagree with that. All right, Ms. Heard presented sufficient evidence of actual malice. Mr. Depp waived any argument that summary judgment should have been granted because he didn't argue it appropriately, is basically what he's arguing here. Let's see here if we can just skim for actual malice. Mr. Depp asserts that the court erred in denying Mr. Depp's motion for summary judgment. Despite that statement, he presented no argument concerning the summary judgment record and relies exclusively on the evidence presented at trial. The conclusion of this section suggests Mr. Depp seeks to abandon any error regarding summary judgment by omitting any reference to this motion and stating only that the motion to strike should have been granted. So he's basically saying, if you don't use it, you'll lose it. And if you didn't reference this, then you've waived it. We have a couple more questions coming up here, but let's get to this here. This is just kind of boring legal mumbo jumbo about preserving your issues for appeal. All right, Ms. Heard could prove defamation by showing either Mr. Depp or Mr. Waldman had actual malice. And this is an interesting argument here. There are three distinct bases on which the common law of agency attributes the legal consequences of one person's action to another person: actual authority, apparent authority, or respondeat superior. A principal is subject to direct liability for an agent's tortious conduct that occurs with the scope of his actual authority, while vicarious liability arises from respondeat superior or a tort committed with apparent authority. Contrary to Depp's contention, Ms. Heard did not rely exclusively on a theory of vicarious liability by maintaining that Mr. Waldman made a statement while acting as an agent. This is because a principal's liability for the acts of an agent is not confined to the theory of vicarious liability. Ms. Heard was free to argue liability arose because Waldman was acting within the scope of his authority when he made the statement. Indeed, she tendered, and the circuit court gave a jury instruction, express and implied authority, which provided an attorney has the express authority to do everything which the client expressly authorized him to do, and the implied authority to do everything necessary incidental to the purpose for which he was retained. How far that goes, like I've already mentioned in other examples, is just a very gray area right now. A principal's liability for the acts of an agent is not contingent upon the agent's liability. For example, a principal is subject to liability to a third party harmed by an agent's conduct when the agent's conduct is within the scope of the agent's actual authority or ratified by the principal, and the agent's conduct is tortious, or the agent's conduct, if that of the principal, would subject the principal to tort liability. This is basically just saying the same thing we've heard over and over again, that the principal is responsible for the agent's actions. And if you notice, Rottenborn saying, we didn't waive our ability to appeal this, they did. And then Johnny Depp saying, well, they waived their issue here because they didn't argue it again. This is something that lawyers often go back and forth on, whether or not something was preserved for appeal. We've talked about whether or not it was preserved appropriately. The appellate court will have to determine that before they even decide if it is a winning issue. They have to decide whether or not they preserve their right to even bring this argument. John O'Rourke, let's get to some questions here. So I'm an independent contractor also, but do work under a national firm's name. Friend, thoughts here. I think if you work as an independent contractor to the actual client that you do, I don't know what it is that you do, but like I said, if you go to fix some plumbing at somebody's house, it's on you if you screw it up. But if you work for, Plumbing Inc., and you're an independent contractor, but they get you all the jobs, then they could be vicariously liable for some of the things that you do, especially if you drive their truck and you use their tools. You may be, some people think they're an employee even if they sign an independent contractor. There's a lot of factors in every state. The factors are a little bit different, but the factors you have to apply the facts to all of the factors to determine whether or not you're actually an independent contractor in a situation. Just because you call yourself, and I'm not saying you specifically, John, but just because somebody calls themselves an independent contractor or signs an independent contract does not necessarily mean they are an independent contractor. Ellen, not Sarah Lee. I was an independent contractor for an insurance company, and we had to pay our own $1 million insurance policy. Doesn't an attorney have the same thing? Yes. He should have a malpractice insurance policy. He should have an errors and omissions insurance policy that would potentially cover this claim. Sometimes insurance policies, though, as we've learned from Amber Heard, don't cover intentional tort. So it may not have covered this. Lexix, thank you so much for the super sticker here. Peter, how do you compare this issue with Waldman against the laundry's attorney, Bernalino? It is similar. I think this was more specific because it was like directed and taking shots at Amber Heard. So I think Bertolino's is even more passive and less outrageous, if you want to say that, since that's what it's being labeled as, is outrageous conduct. And he had even less of a duty to really do anything for Gabby Petito's parents in that case. So I actually think these Waldman statements are more actionable than the Bertolino statement. Ellen, is it a coincidence that Amber Heard purchased her insurance policy, which included defamation, only a few months before she wrote the article? You're allowed to, I mean, you don't buy homeowners insurance unless you have a house, right? That would be stupid. I'm not going to buy car insurance unless I have a car and I'm going to drive my car. So if you're going to write an article and you're worried about it, you can get insurance in case anything goes wrong with that article, right? I don't think she did this on purpose. I don't think she committed defamation on purpose. She was protecting herself. Marina, thank you so much for the super sticker. All right, let's get back to it. Mr. Depp had actual malice. As the perpetrator of domestic violence, Mr. Depp is aware that he abused Ms. Heard physically, verbally, and emotionally. Okay, we can just let that slide because, again, he's making these arguments that hold zero weight in an appeal, but whatever. For that reason, he knew the assertion that there was an ambush, hoax, setup is false. So he would have to know that he abused her on that day because, as we've said before, if you've abused somebody one time, it does not mean that they cannot have a setup, a hoax, an ambush, and make false claims on another date, right? I'm not saying he did. I'm just saying both of these things can be true. He could have been an abuser and she could have also created a false ambush, hoax, etc., where she called the cops and roughed the place up. Both of those statements could actually be true, but he's saying like couldn't possibly be true. Rottenborn must, Aaron Fate said, Rottenborn must not usually write appellate briefs. Yeah, he does sound more like a trial lawyer here, right? It's kind of like more of a closing argument than anything else. He also knows Ms. Heard and her friends did not spill wine or rough up the penthouse because he caused the property damage to the penthouse. That wasn't proven. That's the issue, is that wasn't proven. Consequently, there is ample evidence from which the jury could infer that Mr. Depp knew the statement was false or was reckless with respect to its falsity. Okay, I can buy that line at least. Mr. Waldman had actual malice. This is the hardest part, in my opinion, because based on all the evidence we got from Mr. Waldman, he talked to law enforcement officers, to witnesses, probably to Johnny Depp, and he truly believed, it seemed like at the time of the article, that what he said was true. It may have been wrong, but I think he believed it was true. Mr. Waldman testified that he had no firsthand knowledge of whether Mr. Depp abused Ms. Heard, but claimed he saw some things that show her statements to be false. When describing these things, he testified, so there are two police officers, one domestic violence trained female police officer who testified over and over and over that there was no damage to the penthouse, which Ms. Heard claimed was destroyed. That's a direct quote, destroyed. Based on this testimony, a fact finder could have concluded Mr. Waldman believed there was no damage to the penthouse. This conclusion would have been supported by the testimony of 3 law enforcement officers who responded to the calls to investigate. All 3 officers saw no damage to the penthouse, and the jury could have inferred that Mr. Waldman spoke to these officers or reviewed their testimony when reaching its conclusion that there was no damage. Yet, Mr. Waldman told the Daily Mail there was damage to the penthouse. He asserted in the statement Amber and her friends spilled a little wine and roughed the place up. Mr. Waldman could not logically believe both that there was no damage to the penthouse and that Ms. Heard damaged the property to fabricate evidence of domestic violence. That's a pretty good point. So which is it? Was there damage? Did she rough the place up? Or was there not damage where it was destroyed? So that's kind of interesting to think about. I haven't really processed that, but I'm wondering if they're saying before the second police officers were called and after the first ones, then that's when they roughed the place up a little bit. Interesting. The jury could have found Mr. Waldman's testimony contradicted his belief that the truth of the statement, thereby demonstrating that he knew it was false. Sure. In addition, when making the statement and others as Mr. Depp's attack dog, again, little shots being taken here and there. And when he filed the police report for perjury, simply so he could tell the press falsely that Ms. Heard was being investigated for perjury, Mr. Waldman selectively credited only the evidence he believed was favorable to Mr. Depp and ignored the abundant evidence of Mr. Depp's abuse of Ms. Heard, including the evidence regarding the night of May 21st, 2016. Therefore, a jury could reasonably have concluded that he earlier knew this statement. The statement is actionable because it contains provably false factual connotations. So this, I kind of agree with. Yeah, it was destroyed after the police left. That's what people are saying. I think that's what he was going for, but I do understand what Rottenborn's arguing here, that he said it was fine, and then he said it was roughed up. So maybe they did not explain the timeline well enough. He's just basically saying a reasonable jury could infer this, not that they necessarily did. All right. The statement is not protected speech. Pure expressions of opinion are constitutionally protected. This is where he does kind of protect some of their arguments and their appeal. How long have we been going? 36 minutes. Okay, we're okay. Are constitutionally protected. There is no wholesale defamation exemption for anything that could be labeled an opinion. Expressions of opinion may often imply an assertion of objective fact, and simply couching statements in terms of an opinion does not dispel these implications. Factual statements made to support or justify an opinion can also be the form and basis of defamation. The test for distinguishing pure expressions of opinion from actionable factual assertions is whether the statement contains a provably false factual connotation and is thus capable of being proven true or false. The doctors abandoned their patients and that there were concerns about their competence were falsifiable. Statements that a doctor was engaged in excessive billing, sought reimbursement for services that were not authorized or performed, and was opportunistic and aggressive about pursuing money were assertions of fact. Statement in this case, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouse, thoroughly searched and interviewed, and left after seeing no damage. Boom, no damage. He does say it there. So Amber and her friends spilled a little wine, roughed the place up, and got their story straight under the direction of a lawyer and publicist, and then placed a second call. To me, I think this is provably false. I should say, this is a fact that you could prove was false or you could prove was true. This definitely feels like a factual statement to me. So I don't think we need to go into whether or not a hoax is falsifiable. Mr. Depp didn't even challenge that the statement was something that you could prove was false. Let's get to the next argument. The circuit court correctly rejected the proposed jury instructions on independent contractors. The decision to deny it was an abuse of discretion. Sole purpose of appellate review is to see if the law has been clearly stated and that the instructions cover all issues of evidence fairly raises. We've had issues in cases where we have read a jury instruction that was not a standard jury instruction, had one or two words changed, and they act like this is this big deal for appeal. But in reality, this is correct. The purpose of the jury instructions is to see that the law has been clearly stated and that the instructions cover all the issues with the evidence, which the evidence fairly raises. Whether the content of the instruction is an accurate statement of the relevant legal principles is a question of law. Like all questions of law, is reviewed de novo. Where other instructions are fully fair and fairly cover the principle of law governing the case, the court does not err in refusing an additional instruction. We've been through this in the other briefs. They're going to argue, as I already know, I haven't read it, but that the other instructions they gave fully explained the independent contractor situation they needed to explain in this case. They did not need that additional instruction. Johnny Depp's team wanted the additional instruction. The court did not err by saying no to that additional instruction. The jury instructions fully and fairly covered the principles of agency. They previously explained it. A principal is a person or legal entity with the power or right to control the means and methods of performance by which another person performs the principal's work. An agent is a person who is subject to the power or right of a principal to control the means and methods of performing the work. The next proposed jury instruction, that was the first one. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer / principal. And as to the way he brings about the result. If you find Mr. Waldman was acting on behalf of Mr. Depp, but was not subject to Mr. Depp's control, and or means by which Mr. Waldman worked, you must find that Mr. Waldman was an independent contractor. Both TT and proposed jury instruction number 22 explain the liability depends on whether Waldman was subject to Depp's control with respect to the means and methods of his work. In light of this redundancy, the court did not abuse discretion on not allowing 22. So let's look at them a little closer. A principal is a person or legal entity with power or right to control the means and methods of performance by which another person performs the principal's work. Okay? So it does technically explain it. But to me, it's a much more you can understand, right, why the different lawyers wanted the different jury instructions, because you can understand is an independent contractor is a person who is engaged to produce a specific result, but not subject to that. I feel like the jury could have absolutely found Adam Wald was an independent contractor if they would have given this instruction. Now, did they need it to accurately explain the law? That's something the appellate court is going to have to determine. Of course, they're going to argue Mr. Depp suffered no prejudice due to the refusal of proposed jury instruction number 22 because he was free to argue that based on jury instruction TT, he was not liable because Mr. Waldman was not his agent. And I agree, but it's always easier and better in closing arguments if you can actually use the jury instruction, put it up on the screen to explain to the jury, this is what Adam Waldman is, an independent contractor because he controlled the means and way he directs the outcome, which is exactly, to me, what a lawyer does and what Adam Waldman did in this situation. I firmly believe that. Now, whether or not they could appropriately make that same exact argument without this jury instruction, again, is something the appellate court is going to have to determine. Proposed jury instruction number 24 is duplicative with the given instructions on the burden of proof. Jury instruction 20 provided Ms. Hurd has the burden of proof. Greater weight of the evidence. 24 states a person who hires an independent contractor is not liable for the independent contractor's actions. If you find Mr. Waldman was an independent contractor of Mr. Depp and an employee, you will not find Mr. Depp liable. I guess I should probably have finished 20. Ms. Hurd, this is jury instruction 20, that was allowed. Has the burden of proof, proving by greater weight of the evidence Mr. Waldman was an agent of Mr. Depp and that Mr. Waldman was acting within the scope of his agency when he made the statement. So they just wanted the inverse, right? You got the explanation of, is he an agent? They wanted the explanation of, well, if you find that he's an independent contractor, court said no to those. I, again, agree. Why not? It's an appropriate statement of law. Allow the jury to do this. Really, the only reason if I was a judge, I would keep it out is if I thought it was confusing and it was going to make the jury potentially think something that was improper, like make him think he was an independent contractor, or not. Let's answer some questions here so I can take a break from reading. Adam Ice. Anyone remember the evidence to that? Same picture of a different angle. Spilled wine that was used by AH for two separate alleged incidents. Genius. Yeah, it's almost like Adam Waldman said she spilled a little wine to try to use it, right? I mean, I think he can at least reasonably have that opinion. Beverly Alford. Check out the Dress to Kill Dapper Attorney. Thank you. Be a lawyer. Catherine O'Neill. Thanks for the super sticker. Adam Warlock. The distance between destroyed and roughed up is huge. She said destroyed, spilled wine, making it a mess is not that. I agree with you. I do agree with you. But I think overall, at the end of the day, this could potentially just be seen as a question for the jury. And the jury did believe that Adam Waldman said these things, potentially knowing they were not true or exaggerated in a way that it was trying to hurt Amber Heard and was defamation. So I get that. I personally think as a matter of law, attorneys in this situation should be independent contractors. But if you're going to put it to a jury and a jury looks at the evidence and the facts and applies it to the law as it's read to them, which was all agency law and not a ton of independent contractor law, and that's how they apply it. If you're going to allow it to go to the jury, you got to live with the jury's decision. Will it be a long wait to see if the appeal has traction? Probably. LB Messimer. I'm truly confused. I thought it was all about defamation, not abuse. Why all the rehashing of the alleged abuse? This is Ben Rottenborn basically rehashing part of his closing argument. First question as a member. Welcome, Creed. What if being an independent contractor and an agent aren't mutually exclusive? Or wait, if being an independent contractor and an agent aren't mutually exclusive, why are the jury instructions mutually exclusive? It's because they're different definitions, right? So the jury instructions are defining these terms, and you can have two separate jury instructions defining the terms. Mutually exclusive means you can be an independent contractor and an agent at the same time. I guess that's true, but I think that is absolutely the exception, not the rule. That's why we have these two very differentiated and defined very differently, these two words. Ashling's loving the Be a Lawyer shorts. Thank you, Ashling. All right, back to it here. The circuit court did not abuse its discretion by requiring a redaction of irrelevant and inadmissible portions of the article containing the statement. So this was Johnny Depp's team wanted the portions of the article in to show the context. And now this wasn't a hit piece to Amber Heard. And this stuff was just kind of part of it and really was not aimed at him. Kind of the same way Amber Heard wanted the full op-ed in to prove context. Court didn't allow it. Okay. Decisions regarding the admissibility of evidence lie within the trial court's sound discretion and will not be disturbed on appeal absent an abuse of discretion. It's funny because, again, half of their brief was on the court didn't let this stuff in. The court didn't let the mountain of medical records in. The court did let this stuff in. And yet they do say here it's got to be an abuse of discretion, which is a very high standard. A court has abused its discretion if its decision was affected by an error of law or was one with which no reasonable jurist could agree. It's funny when they take shots and they talk about how high this burden is. It's like that same burden is applied when you filed your appellate brief. That's what I keep thinking here. Redacted portions of the article were inadmissible. Contained statements because it constituted inadmissible hearsay, which was not necessary for the jury to assess whether the statement was defamatory. Purposes of the third assignment of error, the court need focus only on the statement that the jury found was defamation toward Heard. Mr. Depp argues the full text of the article was necessary because it would have shown the statement was not actionable defamatory comment, but instead opinion. As explained, the statement was plainly defamatory and not protected speech. Moreover, Mr. Depp presents no argument or evidence other than his own conjecture that anyone reading the article would have understood the statement as anything other than the statement of fact, and that Ms. Heard and her friends lied about Mr. Depp's physical abuse and property damage. Well, if you're so confident, why didn't you let a jury look at it and determine if they would have found a different context? The fact that the article contained a quote from Ms. Heard's lawyers, additional statements by Mr. Waldman on behalf of Johnny Depp that were factual in nature and references the party's ongoing dispute does not and cannot remove the defamatory sting of the Waldman statement. As the circuit court noted, whether or not the statement is defamatory cannot depend on a third party's decision to put the statement in a certain portion of a certain article. This is because, as the circuit court already ruled, Mr. Waldman did not know what the articles were going to say or how they were going to go to print the article. This ruling was not an abuse of discretion. Mr. Depp's reliance on this case is misplaced because, contrary to his interpretation, it actually simply stands for the proposition that a court may consider the alleged defamatory comment in the context of a longer statement by the same defendant for the purposes of determining whether a statement can reasonably be understood as stating or implying actual facts, whether those statements are verifiable, and whether they are reasonably capable of having a defamatory meaning. So I would say that this argument has some weight that whether or not we read this full article, I do think those statements can be seen from a jury as statements of fact that could potentially be provably false. So I do understand where they're getting from here. This one I could go either way on. Providing context is always good, letting the jury see the full picture. But I also can see how the statements standing alone are statements of fact that could potentially go back to the jury on their own. All right, we'll read the last paragraph here and then the conclusion. Mr. Depp's suggestion that the full articles were necessary for the jury to assess Heard's damages is wrong. The remainder of the article simply discussed fragmented aspects of ongoing disputes regarding Mr. Depp and Ms. Heard's relationship. And the jury was presented with far more details of the relationship through the evidence permitted at trial. That's true. Where were we here? Albeit an incomplete picture due to the court's improper exclusion of most of Heard's evidence of abuse of Mr. Depp. So he's going to throw in here that, listen, this really high standard, but the judge blew it for us. And the jury was presented with evidence of the ways in which Ms. Heard had been damaged by the statement of both Ms. Heard herself and from dueling damages experts. Thus, to the extent the circuit court erred in excluding contents of the article that contained the statement, any such error was harmless. And the way you say something's a harmless error is, even if it would have come in, it wouldn't have made a difference. It's like we fought really hard to keep it out because we thought it was going to make a big difference, but it didn't come in and it really wouldn't have made a difference anyways. It's funny when lawyers make those kinds of arguments. And I do the same thing because it is true. Like we fight about this stuff. And then at the end of the day, we're like, it really wouldn't have even mattered. Like that can be a true statement where we really fought hard to keep something out because lawyers notoriously worry about every single thing in a trial. What's a jury going to think about this? What are they going to think if we use this word? What are they going to think if this witness says this? What are they going to think if we bring a witness like that has this background or went to this school or whatever it may be? Is this kind of an expert? We worry about every little detail. And so sometimes it does come down to the fact that it actually is not that big of a deal and it's a harmless error at the end of the day. All right, let's get to some more questions. Tori, off topic. The jury has the case for the Border Patrol case. Can we go over the closing arguments? I felt the arguments shouldn't have been allowed. I have not seen the closing arguments. I am planning on doing one more video on this Border Patrol case. It didn't get a ton of interest on our channel. It didn't hit the 3,000 likes. So I figured you guys didn't care about it as much. So if you do and people want to see more on it, I was planning on doing one more video after the verdict came out. We can talk some closing arguments, answer some questions, and I expect it to be a guilty verdict. I don't know what you guys think. Adam Warlock, since the jury find it was a hoax, shouldn't the action be or can be brought not by Amber but her friends? Since the jury find that the jury did not, I would not say the jury found that it was a hoax that night and a setup that night and that her and her friends roughed up the apartment. But I think what you're saying is the jury kind of felt like Amber lied about the abuse. So wouldn't her friends have to bring the defamation? I think no, because I don't think the jury definitively found here what's in this comment. Digital design and innovation. We never ask for lawyers to get disbarred. So I appreciate the super chat, but I disagree with it here. So we're not gonna put that one up today. I see some people want that Border Patrol case. So again, let me know in that video, in this video, hit the like button over there. Hit the like button here if you guys are still here. And we want to continue to answer some more questions. We've got about 5 more minutes so we can answer some more questions about this appellate brief. Only 728 likes. Now, 3,000 is a lot. I was talking about the Border Patrol video. Yeah, it is a lot, but it's a ton of time to put into that trial. So if people don't really care about it, I'm going to put more time into the videos they care about. Right? It's not about what I want to watch or what I want to talk about. I try to give what the people want to talk about. You got to give the people what they want, including another Amber Heard brief that we have just completed going through. Additionally, as we're talking about content, a lot of you have been watching the Be a Lawyer shorts. If you have any ideas or funny quotes or things that you think about lawyers that are stereotypical, that you think would be good for a Be a Lawyer short, throw them in the comments. Send me a message on Instagram or Twitter. That's actually the best way. At Tragos Law, give us a follow. And if you have any funny one-liners for lawyers that you think would be a funny video we can get creative with and have fun with, let me know there. And if we feature yours, we will put it in the video description that we featured your Be a Lawyer. But you got to follow us on Instagram and Twitter to get in on that so we can actually have your handle. Okay. I'm going to answer a couple more questions here. So Mary Posa FRR, Pete will be covering the Balwani sentencing. He was ready to do it, I believe, last week. Then they continued it, I think, to this week. I think it's Friday. He's going to be doing a video either Friday night or Saturday. So we will be posting it either this weekend or early next week. Absolutely, we will do it. Is that Tyler behind you? What do you? Oh, you can see John. No, this is John right here. Yo. All right. I didn't see you before until you closed the document. Oh, okay. Well, now they can see you. Mine would be don't become a lawyer. Way too much reading. So it's funny you say that because we just did one about reading today and about how much reading it is to be a lawyer. So check that out. Peter, when are you planning on doing the members only video? We don't have it planned yet, but we will post that on the members only community page with at least a week's notice so everybody can plan to show up for that so we can have fun there. All right. I don't see any more specific questions about this brief. I do see some suggestions for other cases. So keep them coming always in the comments and in the chat. and in our messages on social media, like we said. And if you guys have any questions about real injury cases, feel free to reach out to me, because if you're new here, real practicing personal injury lawyer in Florida. So anywhere in the state and really the country, we can probably help you out or find somebody to help you out with any injury cases, car accidents, wrongful death, slip and falls, nursing home negligence. Let us know. So that's all we got. Angela Parker has liked, shared, subscribed, and hit the notification bell. Everybody else follow Angela's lead. On the way out, hit the like button. It's easy. I appreciate everybody joining me. This was fun. This was more fun and enjoyable than I even expected it to be, because of you, because of the chat. We got through this brief a lot quicker and easier than I thought. So I appreciate everybody coming. Appreciate everybody who joins along for the ride in the chat. Until next time,